Right, good afternoon. Apologies for being delayed. My friend and colleague in Comrade Vessel has a perfect ability to conceptualize things in terms of three often and doors, divisions and lines. So I thought the only thing I should do this afternoon is say good afternoon, welcome, and thank you. And that's it. But maybe the thank you will need a little bit more. So let me start by thanking Vessel. This was his brainchild. He's been talking about this since last year. So thank you for bringing all of this together. Thank you to all of you who are here, also those joining us online. Thank you. You were first on our list as a participant. So thank you very much for being here. As always, Adelaide and Schlamschla and AV, everyone for their assistance. Henk, who will prudently moderate. Thank you very much. But then most importantly, Albi, for accepting our invitation, for being here, but also for 60 years ago, insisting on having books, reading materials and writing materials. And I think your request and the state's and the court's resistance underscore something about the importance of words and ideas and the revolutionary power of it. So thank you very much for being here today. I was thinking about the divisions, and we often talk about the past also because we think about the present and the future, and we're hoping for a better or different or maybe a more just future and present. And I was just reading on the plane these words, and I'll leave you with these words, and maybe something else will come out. But Derrida, wondering about the possibilities of a new order of law and a democracy to come, writes whether there's a certain idea, an other that has not yet arrived, perhaps. And he says, if it has indeed arrived, then one has perhaps not yet recognized it. So let's see. But I hand over to Henk and Alvin. Thank you so much.
And thank you. And no thank you. What have I landed myself in? It's speaking about myself, being myself, thinking myself. Wow. So I've tried to divide up the storytelling, and the first will be the experience. The second will be the law. The third will be the literature. And the fourth will be reflections on reflection. So the experience. 1st of October, 1963. Can any of you remember where you were on the 1st of October, 1963? I was the 28-year-old advocate at the Cape Town Bar. I'm going to work. It's an early spring day. It's cold. I put on a kind of woolen suit that had been made by, his name might come back to me, Sietien, I think his name was. He was in the South African Coloured People's Congress, part of the Congress Alliance. It was the ANC, South African Coloured People's Congress, Indian Congress, and had been the Congress of Democrats. And he was a tailor. So he made suits for the comrades. And I'm wearing the suit. And I'm looking for parking. And I'd received my second banning order. The first banning order when I was a student at UCT, Minister of Justice has delivered to you an order that sets out things you're not allowed to do anymore. The main is not attend any gatherings. But I could still continue with my law studies, my exams, qualify as an advocate, practice at the law. The second banning order, some years later, first one was for 5 years, much more stringent. And it restricted me to white areas of Cape Town. I would drive out to the court in Belleville and I'd say, I'm just going to go up the N1. The minute I got out of Cape Town, I'm breaking the law. And I used to park the Advocates' Chambers, 1 Dodge Street, right opposite the entrance to the what's now the High Court. You know the High Court in Huron Street. And tall building there, and I was on the 10th floor. And I used to park just on the other side of Long Street, what's now the Bullcup. I was no longer allowed to park there anymore. I couldn't even drive through the Bullcup, committing a criminal offense, not a white area. So I had to find somewhere else where I could park. I found the parking, and I'm kind of dreamy at the best of times. And 8:30 in the morning, I'm even more dreamy. And I'm about to go to work, and I'm even more dreamy about the cases on hand. And suddenly I seemed like 3, 4, 5 white men who were idling in the street. I'm reading the newspaper, I read something else. Suddenly they spring alive. You see it in movies, the secret police merging with the environment, and they all come to me. And one of them, and they all seem to be very tall, very big. We were detaining you under the Act something commonly known as the 90-day law. But first we're going to search your office. And I'm feeling really indignant. There's then called the Supreme Court of South Africa, Cape of Good Hope Provincial Division, just across the road. I'm an advocate, a lawyer going into work, and they're just detaining me. There's no charge. It's not saying you committed this offense or that offense, the other. They're just going to lock me up. I'm in the struggle, in a youth movement for the modern youth society. And you're in the struggle, you know you're going to go to jail. Even my office, I've taken over from a friend, a comrade called Lima Foreman. I had finished my exams in 1956, December, and on the 5th or 6th of December 1956, treason trial arrest. I was raided but not arrested. Lionel is flown up to Johannesburg. His chambers are empty. I'm looking for chambers. I take over his chambers. And I mention that because he had real rubbish furniture. If you know you're going to jail, you don't spend a lot of money. And you justify it because I'm a revolutionary and I'm not going to waste money on fancy furniture, and those are not the kind of clients I want anyhow. And what's the point? I'm going to go to jail. So I inherited his crappy furniture. And I'm accompanied up the lift, these tall guys, into my office. They're searching. And I'm feeling kind of indignant. They're going through my documents. These are cases, privileged information. I'm defending people, statements they've made. Oh, I'm kind of protesting, kind of standing up for my rights. But it was so feeble. I was quite brave then. I was still quite strong. This is my first, not my first time being arrested, not my first time to be locked up. The first time now it's going to be going into solitary confinement, endless, being locked up. They go through all the drawers and they discover in the one bottom drawer a publication called Fighting Talk. It used to come out monthly. It was edited by a journalist, Ruth First, who is known because she was later blown up and killed in Mozambique while working at the Center for African Studies. And it was banned. And to be in possession of banned literature, we go to jail. And we were discovering they always found a copy of Fighting Talk. I'm sure they actually planted it there. And I'm not really tidy, so I couldn't be absolutely sure, but that would be a justification now. This openly published, nothing violent in the text, anti-racist, anti-apartheid, but it's banned. And if you possess a banned document, you go to jail. There was an exhibit that I'd used in a trial. I've been involved in a murder trial, wrapped up in newspaper. They're very excited. They think it's a bomb. And it's a bottle of brandy. And it was the exhibit we used to prove that it was in fact a shebeen at the site of where the killing took place, and the state story was full of lies. And they very cock-a-hoop. And I'm trying to be strong. Down the stairs, down the lift, into the car, driving where they're taking me. It ends up, it's in Maitland. Not an area that I would frequent. I used to sell the New Age newspaper in Kensington, which was nearby. And I'm being signed in, taking down corridors, move along, open the door. Inside, wah, bang! The sounds of prison are just different from the sounds of life elsewhere. Everything is metallic, everything is a command, everything is staccato, harsh. And I'm saying to myself, so this is what it's like. The freedom fighter, you read books about solitary confinement, you read books about torture, you read books from, there's a guy, Henri Alleg, who been imprisoned by the French in Algeria. He was a Frenchman on the side of the Algerian freedom fighters. Beautiful introduction by Jean-Paul Sartre on torture. A book by a Czech communist who'd been captured by the Nazis during World War II. Wrote a book called Notes from the Gallows. And a patriotic guard had smuggled it out. Beautiful, poetic, lovely. His name might come back to me later. We read poetry by a Turkish poet called Nazım Hikmet. He'd spent about 20 years in jail, revolutionary, and their poems about love and life and struggle and personality and all these themes. You think somehow reading all this stuff will immunize you, it doesn't. This doesn't. One, alone in this concrete cube, and I look, there's a mat on the floor, there's a little toilet, high window. Da-da-da-da. I use Beethoven to da-da-da-da. And I walk around. And then I'll sit down. There's nothing. No one to speak to, nothing to do, no activity. Phew, so this is what it's like. And I stare at my toes, stare at the wall, my toes. 3 minutes have gone by. They've taken away my watch, they've taken away my tie, they've taken away my shoes with laces. And that was the beginning of the second worst experience in my life. You don't know how long it's going to last. You feel strange. You want to be brave, but you're not fighting anybody. There's no enemy. You're not in battle. You're not standing up and charging at the enemy. Da, da, da. It's like you're just sitting alone. Nothing, nobody. I remember on the second day commenting to one of the warders. I could never understand why killers, tough, brutal men would confess so often when they're taken into custody. And I said to him, I can now understand why. I'll be like the scientist, participant observer, feeling that. And of course, he reported it to the security and they pounced on me straight away. It was a dumb thing for me to do, and yet the need to communicate, even to communicate that thought, to have somebody listening, to be in touch with somebody was immense. And I've got a 40-minute session here, and I've only been 10 minutes in jail, so I'm going to take you through the whole 90 days. But part of me feels rage. The rage is not directed at the security police. You know they're the enemy, and you can't have rage when you're in a position of powerlessness, because then you're going to lose. So who was my rage directed at? The legal profession, the judges, the law. How can it happen? An advocate going to work, upholding the law, can be just plucked off the street like that, thrown into prison, no contact with family, no lawyers, no charge, no being brought to court, just locked up like that. And an experience that came so really strongly to me was how your emotions now are not contained. Everything is exaggerated, enlarged. So even the anger now becomes enlarged. And it's anger at the pretensions of law. Rule of law, rule of law. And this happens under their noses, in front of them. A law passed by Parliament. Nothing. And I felt such hatred for the legal profession. Bogus, full of false promises, pretentious, self-righteous, and this can happen. I'm not sure how many days I spent in Maitland. That's another whole story, and it's in the book, The Jail Diary. But I moved to Wynberg, and the cell now has a bed. Just seeing the world from the floor. It's so different. When I would hear the guards coming, I would make sure I could jump up. I didn't want them to see me lying on the ground, but I spent most of the day on the ground. I would do exercises, I would sing, I would do all sorts of things to try and keep myself sane. Now, at least in Weinberg, it's attached to the magistrate's court. There's a tiny little courtyard in front, the toilet, and a bed. Wow, bed, actually, lie flat, not on the floor. And slamming and hearing the kids 5 in the afternoon, juvenile whipping, screaming. I would cover my ears. Again, rage at the law. This is the law. The law is brutal. It's hitting terrified children. And you'd hear the first, second, third, and the scream got louder and louder, up to 6. Then I'd come out and do my exercise, and about 20 minutes, half an hour exercise, I'd run round, and I'd see bits of broken cane, and warders are reading the burger and drinking their coffee. Come on, was it you? Was it you? Was it you? And the station commander comes into my cell one day, and he's waving a piece of paper. If they'd listened to me, this would never have happened, he says. I don't know what he's talking about. And he gives me the piece of paper, and I see, now the only book I had was the Bible. And I grew up in a very secular home. I've never read the Bible, never studied it. Never went to synagogue. I wasn't part of the organized Jewish community as a faith community, although I'm really proud to be a Jew. And now I'm reading it, and I'm rationing myself 2.5 pages a day. I don't know how long I'm going to be in. So it's thin paper in columns. And this piece of paper I've got is not in columns. My eye gets a little bit confused because it has to read across the columns. And it says, and die Hoogrechtshof van die Weskaap afdeling, something like that. And then I see, in the case of Sachs versus Rossouw, before Banks, J, and Van Vincent J is the older judge, and Banks J. It is hereby ordered that the applicant, that one, be allowed to have access to reading materials. 2, the applicant be allowed to have access to writing materials. And it's signed by the 2 judges. Wow! The law is the best thing in the whole world. Humanity's never known anything as beautiful and wonderful and magnificent as the law. Again, exaggerated emotion. But I'm not letting Captain Snowman see this is my emotion. I'm not sharing it with him. So keep tight-lipped. And then he says, grumbles something, that he'll give me something to read. And it wasn't the Staatscourant, but it was something like that. Some police gazette. And then the only other literature he had was the Huisgenoot. It's a weekly publication of Afrikaans family publications. I actually became addicted to the Huisgenoot. Why? About people. It had dialogue in it. You would have stories, and there's one story about the woman who is a librarian in this little dorpy, and she's a lovely person with big dreams. And one day, this horrible man comes in, and he's a professional from Pretoria, Johannesburg, and he walks right past her, and he doesn't even look in her direction, and says something that actually doesn't exist. Well, you know how the story is going to develop. It. You wait the next week for this contact, and they break down, and the third week they get married. And I loved it. And I loved it because it was so benign. It wasn't conflict. I couldn't bear conflict. I couldn't bear anything where you were exposed to a crushing reaction from people who had power over you. Then I said, my friends can send books into me. No. They were worried that they'd have messages. You have to get books from the library. And I'll deal with that now in the literature part of the presentation, that story. But I did get pen, pencil, and paper. And I still remember now, at first, I was scared to write. I was scared to reveal anything of myself, because I could pick it up. And the story came to me about Sir Thomas Beecham, who was a conductor of the London Philharmonic Orchestra, elderly guy, spent like a gap year in England, 54. And I would hear this great conductor, 1990 seemed like 2,000 million years old, sitting on a little stool and conducting. And he introduced Sibelius to English audience. And he was notorious for his wit. I tell the story with some reluctance now, because, and you'll see why. There was a woman cellist playing in the orchestra, and she's playing, and he stops, and he says, "Madam, between your legs you have an instrument capable of giving pleasure to millions, and all you can do is scratch on it." Now, we thought it was very funny, and in a way, it was funny. And it symbolized what I was doing. All I could do was scratch on that piece of paper. But of course, he was a misogynist. He didn't like women in the orchestra. And it was his rather cruel way of putting it down. But I did, okay, this also comes from the literary part. I moved to Caledon Square. I think, oh, maybe this is good. They're going to release me. And I'm scratching the days on the wall like all good prisoners do to keep track of time. And that's the 90th day. Policeman comes in, and I see he's carrying my suit. This is now 90 days after 1st of October. It's end of the year, it's hot. And this thick, heavy woolen suit, put it on, get my tie back, I get my watch back. I'm taken downstairs, in a tiny little cell then. And the station commander actually took one of the books I got, is The Rise and Fall of the Third Reich. And he'd been in World War II. He took the book and he never gave it back to me. And he's very jovial, and yeah, you're free. I say, really? The phone rings. Yes, no, he's free. It's my mother, obviously, on the line. I'm very suspicious. I walk out now, got a little sucky with clothes of war in prison in it. And as I get to the front door, the same Sergeant van Dijk, who detained me before, comes up, puts out his hand. In those days, when you arrested someone, you had to place your hand on the body. Something taken over from England. I'm detaining you under the 90-day rule. So go back to the cell, they take my tie away again, they take the watch away again, and the shoes with the laces, and it's all going on once more. After a couple of weeks, I'm told my mother is going to be brought to see me in my way. Quite exciting. And I'm taken to a particular space. She said afterwards she had her hair done, she bought a dress specially. And as she comes in, I'm starting to they thought she would try and break me down, that she would try and say, I'll be, getting anywhere, tell them what you know. And I'd refused to answer questions. I said, unless you tell me what the questions are. And they would say, we can't tell you what the questions are until you agree that you will answer the question. Like a little game we play. And someone who'd been in the struggle herself, what she did was, I wasn't going to say anything that could be used. It's more important for her that I maintain my integrity and that she got her son back home. And then suddenly, it's after 168 days, they're now bringing the clothing back. It's real. It's not the end of 90 days. And the courts had held, the top court, Appellate Division, the 90-day law, you can be held for 90 days. There's nothing to stop the police from releasing you for 3 minutes and detaining you again. You'd think judges would say, okay, you have one shot, 90 days. That's as long as, if it had been longer, they would have said longer. But the court is leaning in favor of holding the protection of the basically working community society. So that's the experience. Safe to say that I put on some khakis. There were khakis I put on. When I'm telling the story in New York or in Nairobi, I say khakis, people don't know what I mean. It's lovely now in South Africa to say I put my khakis on and I run. And I run 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 and run and run through town. I'd grown a moustache because the only self-determination I had was moustache. Through town, main road, Greenpoint, down to the beach road, along the beach road, on the beach road, that little incline that seemed so gentle. It's like a mountain at the end of Beach Road, going up to the road to Clifton. Running. I see a guy taking pictures, and I say, would you mind? I've just been released from jail. Can you take a picture? He said, yes, but the sun's in the wrong place. So I have to turn around and run the other way, and he takes the picture, and I lost him somewhere afterwards. And I run. And meanwhile, the word has got out, and I go down first beach, down steps and little steps, and I fling myself into the water. And I see the advocates, some of my colleagues have come, they're in these suits with shiny shoes. And I only discovered recently that they didn't all see me at once because that would break my banning order. So they sat on a rock and they came one by one to see me in the waves. Okay, so that's the experiential side, the legal side. The case is now known as the case of Rossouw versus Sachs. I should tell it in a legal voice, but I'm not going to. And I'm angry, obviously, with the outcome. I'm already out of jail. It's taken on appeal by the state. And the Appellate Division, it's now the SCA, overturns the decision of the Cape Court. And I might mention the decision of the Cape Court was buttressed by a decision given in the Transvaal court in the period of the labor agitation on the gold mines, 1919, 2021, where the judges had held that detainees locked up under emergency laws then were entitled to reading matter and writing material, that the detention is to stop you from carrying on the mayhem, allow investigations to go on, but unless the law expressly allowed the authorities to deprive you of what ordinary waiting trial prisoners got, you had to have it. So there was precedent, and there was nothing in the enabling law to say that your right of access to reading and writing material could be curtailed. It was Chief Justice Ogilvie Thompson wrote the judgment. So it wasn't like, as people used to say, these Boere put onto the court now to uphold the Nationalist Party government. It was Ogilvie Thompson. His family afterwards very heavily engaged with Anglo-American, Oxford trained, and stating in the decision on the argument of the applicant, it would mean that if, while he was at liberty, he had cigars and champagne, he ought to get cigars and champagne in prison. Now, Ogilvie Thompson had never been in prison himself, or even close to it. And you realize this example he's given is okay for somebody who would go to his club and have cigars and champagne, but totally irrelevant to that actual kind of situation. And I was angry, not just at the outcome. My vanity had been so enthusiastic about this decision. Even in apartheid South Africa, the courts can come up with a decision in favor of liberty when they're not compelled by the law to restrict the liberty, even in South Africa. And I'm also angry because his name is now coming before my name. It's not Sachs versus Rossouw now, it's Rossouw versus Sachs. So even he gets the lead in terms of the denomination. And some years later, I read an article in, I think, the South African Law Journal by Matthews and Albino. Last night I couldn't remember his name, Albino. And Professor Matthews was one of the outstanding law deans in South Africa and University of Natal then, tearing into the Appellate Division decision. And Albino is a psychologist. And that's very rare for lawyers to now introduce material that's not strictly in the legal canon. And written a long article, very trenchant, very powerful. Obviously, I think it's well written and good. But I'm also feeling elevated in that sense that the experience I'd had is now being used as part and parcel of the rejection of apartheid and a denunciation of the courts that are going along with apartheid. The legal part should end there, but it doesn't. $1980s. Maybe late 1970s. I'm in Lusaka, and I'm not in Lusaka. I'm working in Mozambique in the Ministry of Justice. I've been at the University of Online, and I get a phone call, and it says, and they're very excited. President Oliver Tambo wants to speak to you. And pick it up, and we also after my health and look at the situation, this, that, and the other. Finally, could I come to Lusaka? He knows it's difficult, my work's very important, but if necessary, you can speak to Simone Michelle, and he said, of course I can come, and I'm allowed to go. And a couple of weeks later, it's down through a sanitary lane in Lusaka to the very modest office. And he said, we have a problem about ANC detainees. There's nothing in the ANC constitution. What do you do with enemy agents? And he said, we don't have any regulations. I said, oh, well, they're international instruments that say no inhuman, degrading punishment or treatment, no torture. He says we use torture. It's torture. We're fighting for freedom, we use torture. And he said with a bleak face, the outcome of that was he asked me to prepare a code of conduct for the ANC in exile, which will forbid torture, will demand humane treatment, even of, maybe especially of captured enemy agents, as well as processes of law. People are being charged with different things, the right to defense, range of punishments. The most important legal document I've written was that. I helped with the writing of the Constitution, I helped with the same-sex marriages case and so on. That, to my mind, is the most important. And then I go forward even a little later now. I'm in Mozambique, after I've lost my arm in the bomb there, placed myself with Sovereign Security agents. And it's what's called the Tami Zulu matter. Tami Zulu, an ANC MK commander, who'd been detained by security, come out of detention and died a few days later. And I'm on a commission, I asked to be on a commission to inquire into the death. And I'm full of anger. I'm full of anger. We've got to expose this. We're fighting for freedom. How can we possibly do it? And I go to the ANC detention sector in Lusaka, and I feel such dismay. And it's back again in that kind of atmosphere. There's one detainee, it was a woman. I'm alone with her. And I see she has only one book. It's not the Bible. It's from the selected works of Lenin. I feel a kind of nausea, a replication of this kind of idea. I'm alone with her, and she makes it clear there's been no abuse, there's been no violence towards her, anything. It's just very, very boring. And I say, I can't go into your case, I'm just checking out. And I go back to the hotel and I cry. I cry because we are now doing that. Before we were the ones who'd been locked up, now we're locking up. Just that sheer emotion of it. Tami Zulu matter is another whole thing. That I started off determined to expose our security, but it turned out that from our medical evidence, he'd been living with HIV, and that's why his health had succumbed, and he came out, and he didn't complain to his doctor friend about ill treatment at all, but he died 3 days later. And there was some indication in the hospital report that there might have been poison in his blood. And I took the blood for medical analysis in London, and they said there was no indication, but if there was poison, the lapse of time could have resulted in it being disappearing. Very, very painful case. And when it came to writing the report, the cause of death wasn't physical ill treatment. Were there grounds for locking him up? And there were grounds for locking him up. It wasn't just a political thing. A number of ANC MK people had crossed from Swaziland into South Africa, and the police were waiting for them. And only 3 people knew, and 2 of them were out of the country, so he was almost the only. There was sufficient reasonable grounds for detention, but to my mind, not for keeping him locked up for, it was 11 months, because they couldn't get enough evidence one way or the other. So my colleagues on that committee felt no, difficult circumstances, not too long, and I felt it was too long. And you all know that I was hammered at the JSC Judicial Service Commission hearing. Why didn't you write a dissenting report? I wasn't a judge then, but I made it plain in writing up that at least one of the persons objected to it. So in a very curious way, this whole theme, in an inverted way, followed me right through my life. I'm just going to now not tell you, but just summarize the literary part. Once I got my pencil and paper, I started making little notes, not sentences which they could read, but just reminders of things that had happened to me. I'm going to write a book when it comes out. And that was my way of fighting back. I didn't have the courage and strength to go back into the underground and carry on with underground struggle. We were being destroyed. And I couldn't bear the idea of being in that isolation again, but I could write. And I wrote the jail diary, like in secret. It was a criminal offense for me to write for publication. It was a criminal offense for people to type what I've written. It was a criminal offense for people to carry it out, to post it, to publishers in London, but the jail diary came out. And the jail diary was made into a play afterwards. It was put on by the Royal Shakespeare Company, and a very amusing sequel. I'm at a conference in India, and I meet the judge who became the Chief Justice in England, Nick Phillips. And he said, if ever I'm in London, I must come and stay with him and his wife. And 2 years later, I'm going to London, and I'm staying with the Chief Justice, head of the House of Lords, that's now moved to its own Supreme Court. Why? Because he'd seen the jail diary by Sachs. And the case that he held that day was what it means to be a Jew. Who is a Jew? Because a mother who converted to Judaism wanted her 2 boys to go to the Jewish free school, and the rabbis in charge said, no, you're not a pure, and not pure Jews that can't go to the school. You know, the law sort of came in that indirect way. The literature came in, it took over. So I'm known for the jail diary of L.B. Sachs, not so much for the Rossouw versus Sachs case. Maybe today's event will elevate that slightly in the competition for international and eternal fame. And then just finally then on reflections, it's actually messing me up a little bit. Not seriously, I'll easily get over it. But now I'm talking about myself, and I'm talking about myself as a detainee, and I'm talking about myself as a lawyer, about having been in detention, and then as a writer, and it's like reflections of reflections of reflections. Maybe after the discussion, I don't know, maybe the soothing words of the speakers to follow will sedate me a little bit, and we'll get through the day without further perturbation. I've never used that word before, but I like the idea of being without further perturbation. Thank you.
Thank you, Albie, for the unique way in which you blend personal narratives and the political. And I think this session has really laid the foundation for our further reflections on the, first of all, on the role of law and legal interpretation in underpinning and legitimizing, but also challenging the violence of the apartheid state. And then secondly, also for our reflections on the continuities and the discontinuities between legal interpretation under apartheid and under a value-based constitution. On the program, we said that we will move directly to the next session, but perhaps there will be time for questions at the end. But perhaps if anyone has a question now, we can set aside about 5 minutes for questions and then move to the next session.
While people are thinking, can I just add, when it came to writing the Constitution, I put up my hand very early on, no detention without trial. I think we're the only constitution that has those words in it. There are lots of constitutions that indicate people shouldn't be detained unless there's access to court and so on. But that phrase, no detention without trial, had to go in because detention without trial, which afterwards became something in the Terrorism Act that allowed for people to be locked up in that way, it wasn't simply the denial of the rights of accused people. It gave a safe place from the authorities' point of view for torture. It turned the whole justice system inside out. The people who were really determining guilt and punishment were the security, and the judges more and more became, down the line, the rubber stamp for it. And if we wanted real procedural freedom in South Africa in future, we had to emphasize no detention without trial. So in a state of emergency, you can have detention without trial, but even there, it's subject to dignity, human dignity, as a non-derogable, derogable right.
I see no hands, so shall we save all the questions for later? Vessel.
Okay, thank you for the talk. What struck me is the ambivalence that you speak about being inside a young lawyer, part of the reporting arrangement, immediately becoming an outlaw, an outsider, with ambivalence towards the state high court judgment and the anger towards the Appellate Division. This neither in nor out relationship with the law. And my question to you is, if you overcome that, if you're saying that ambivalence towards the law, why do you want the Constitution at all? And do you think that ambivalence is a precondition for the ability to exercise judgment as opposed to reasoning? And those two ways of thinking that you contrast and ultimately about
It's something stronger than ambivalence is needed. That sense of massive contradiction. And I felt that even before I was thrown into prison. I'd be at UCT and I'd hear the lectures. Professor Mandelbrot and Jeannie van der Poel, I think, Professor van der Poel, and beautiful phrases about the law, and I'd write them down and I'd pass the exams. And then at night I'd go down to the informal settlements and be in a shack, and there'd be people just a candle, we see the whites of the eyes, the whites of the teeth, and it'd be a little study class. The professors believed in the law, but they weren't fighting for justice. They favored justice. The people in the Sachs hated the law. The law was the police on their tail all the time. This, that, and the other. The law was the enemy, but they give their lives for justice. I felt that ambivalence. It wasn't even an apartheid thing throughout the world. The law is on the side of the wealthy, the privileged, the people in strong positions. The law is actually not there, by and large, to support the so-called despised and rejected of the world. And I mention this because when it came to writing our constitution with a different vision, an emancipatory vision, it now gave me a different view of what the law could be. Fundamental rights, a very powerful set of values expressed in the preamble, why we have a constitution, justice in the past, acknowledging that, fighting for freedom, creating a non-racial, non-sexist society, foundational rights, a Bill of Rights. Now I see law has a potential to not stop at the entrance to the mine, not stop at the entrance to the factory, not stop at the entrance to the home. The law can now be used by ordinary people in important ways. And that was healing for South Africa, at least in conceptual terms, and healing for Albie. And becoming a judge now with that mandate, a mandate, not my personal mandate, not from political organizations, the mandate from the nation expressed through the Constitutional Assembly, adopting 490 people, not few individuals, 490 people adopting that law was actually very healing for me. So in that sense, I can be unreservedly in favor of law's potential. And the way I expressed it once was we should always remain skeptical about law's pretensions, but never be cynical about law's possibilities. What the difference? Skeptical about the pretensions. Yeah, the law. But never be cynical about what can be achieved. And then you fight for the dream, the vision, the possibilities, what we struggled for, why our people went to jail, why I lost my arm. It wasn't just for power. They didn't do it for power, actually. It's for beauty in the world, the beauty that people have, the beauty people are capable of expressing. And so from that point of view, I can be an ardent lawyer, but without believing in, if you like, the hype that's often associated with law.
Thank you. I think on that note, I think it's a good note to move into the second session. So you please join us in front. One of the things that always struck me about Rossouw versus Sachs was that from an interpretive standpoint, the speaker isn't very nice. Can you hear me? Should I switch it off? From an interpretive standpoint, it doesn't seem to be a clumsy or incompetent judgment or interpretation. It seems to me that the judgment in Rossouw versus Sachs is in many respects cognizant of the choices the judges have to make. It also seems to me that the actual interpretation of the relevant piece of legislation was not an implausible interpretation. This isn't a piece of naive legal formalism. And that is, I think, what makes this judgment so striking. So there are two plausible interpretations of the law, and the judge, the Chief Justice, chooses the one which is pro the status quo, which basically gives the right of psychological compulsion to the authorities, instead of an interpretation which would at least provide some room for individual freedom. So linking it to this session, it also seems to me that that is perhaps part of the reason why we are still talking about Rossouw versus Sachs today. In many respects, it seems to be a cautionary tale about what happens when legislative purpose is divorced from underlying legal and constitutional values, such as freedom and equality. Now, our next speaker is Hugh Corder, who is well qualified to talk about these issues for many reasons, one of them being that he has written extensively on the apartheid judiciary, but another being also that he has played a role in the constitution-making process. So I think my money is on you also to help us make the link, or to further develop the link between the history of apartheid legal interpretation and interpretation and I suppose the interpretation clauses in the Constitution.
Thank you very much, and thank you for the opportunity to be here and participate in this event. It's always a hard act to follow something like we just heard. It's not the first time I have shared a platform with Albie. Last time, a year ago, I went first. And that was kind of easy, but it wasn't on the exact same theme. And as opposed to him, I'm surrounded by textual authority, if you like, or documents from which I wish to quote. Top of my pile here is one of my proudest possessions when I went to become a student in England. It's called Justice in South Africa by Albie Sachs, published by Heinemann in 1972. It was Albie's PhD thesis. And of course, not available in this country. There's a little price at the front here, £4. I got it at a second-hand store in Oxford or Cambridge or wherever. Okay, so my brief today, and I got a partial brief from Professor van Marle and a follow-up brief from Professor Leroux. And the critical elements which I'm going to focus on are the following two. First of all, to focus on the record of legal interpretation from 1964 to 1994. So to break the 60 years since Rossouw versus Sachs into two 30-year periods. And I'm going to focus on the first 30-year period because that's the part about which I'm probably most qualified to speak. And to wonder is the second question that was posed to me: to what extent did the interpretive history in Rossouw versus Sachs and subsequently, and maybe just immediately before that, in Rossouw's case, which Albie referred to, but not by name, to what extent did that influence those who were honored and privileged to be involved in drafting the first Bill of Rights that we had, the Transitional Bill of Rights, which governed us effectively from 1994 to 1997. And that's my brief, as Professor Leroux put it. What did the Rossouw judgment represent? And was there a strong sense in the early 1990s of a break with the past represented by Rossouw? I also, though, as you will see, am delighted that Albie has mentioned both rage and celebration in relation to the law. And the question we had just before this intense ambivalence about the pretensions of the law and the potential of the law in being in one breath. Because the focus of many of the lectures that I have given to the first year students at UCT over the past 15 years or so, and just completed that on Tuesday, again for this year, has been the rule of law from 1879 in this country, for good reason, to 1989, ending with the state of emergency, ending before the transition, because and that's the next phase of the course. So I am somewhat obsessed by the rule of law, and my understanding of the rule of law will become clear in the remarks that I'm going to make. But I also can never speak on this kind of topic and in the company with Albie without acknowledging my immense debt to him from the first time I met him in person in Harare, January 1989, which was the first public occasion upon which in which he participated after the devastating effects of the bomb in Maputo. And that was a gathering of South African legal academics, mainly Afrikaans speaking, with the ANC Constitutional Committee and its leadership in Harare, under the guise of a conference convened by the Dean of Law at Harare University, Reg Austin. Let me also say, although I will be talking quite a lot about the law of interpretation, because I understood that to be my brief as well, that the last time I lectured the law of interpretation was entirely in the then other official language, Afrikaans. It was at Stellenbosch University, and I had to teach a third year course called the Inleiding tot die Publiekreg, Introduction to Public Law, and part of it, half of it, was on the Uitleg van Wette, the interpretation of statutes, and our textbook was the first ever academic text published in the Afrikaans language, written by R.C. Steyn, who subsequently became the Chief Justice in the 1950s. And that was doctrine. It was heretical in many ways to depart from the almost biblical nature of R.C. Steyn's text in the Uitleg van Wette. Since then, I haven't taught interpretation, but I've just kept abreast of some of the developments, although I don't claim any particular expertise in it. And the second tribute I want to pay is to my close friend and colleague, and one of the founders of RULCI, Professor Lawrence du Plessis, because I met him in sometime in the mid-1980s while I was lecturing at Stellenbosch, and he kindly invited me to Potchefstroom, to the university, as it was then called, the Potchefstroom University for Christian Higher Education, and I gave some guest lectures there, and Lawrence then rather oddly, he replaced me at Stellenbosch when I moved to UCT in mid-1987 to take up the chair of public law at UCT. And even more significantly, and I'll come back to this, Lawrence and I were two of the 4 members of the technical committee which drafted the first Bill of Rights, the Technical Committee on Fundamental Human Rights at Kempton Park in 1993. We used to fly up and down together every week, and we would plan and strategize on the way up and drink good wine on the way down. But it cemented a very good friendship, and you will see from what I'm going to say, the extent to which Lawrence du Plessis knowledge, wisdom, and influence infiltrated and is exemplified in the interpretations clause, both in the interim and the final constitution. Lawrence and I wrote a book immediately afterwards in 1994, a book called Understanding South Africa's Transitional Bill of Rights, and I'll refer to that from time to time. Lawrence was the chief author of chapter 3 in that book, which is about a 30-page chapter dealing with both statutory as well as constitutional interpretation. This seminar or workshop has required me to think about lots of cases and judgments dealing with the kind of issue which faced Albie Sachs during his 168 days of detention, and particularly the access to reading and writing materials. So I would just like to say that it has, in relation to ambivalence about law and the rule of law, it has never ceased to amaze me that after centuries of deprivation through the law in this country, upon liberation, there was a congruence of view that we should be governed under law, government under law, supreme constitution, and so on and so on. There's I think, a really good book which traces that process from 1652 to the year 2000. It's written by a man of German origin, Jens Meyer Henrich, and it's called The Legacies of Law. And I would thoroughly commend that for what Albie was referring to as the enduring potential of law, which sparked a degree of faith in the informal settlements in that justice was potentially possible through the law. And that's what motivates me. So I'm going to focus on the judicial track record overwhelmingly, because who develops our law of interpretation? Sure, academics can have influence, and they certainly do and did from time to time, but the judges are the ones who interpret the law. And my argument is going to be that by tracing the judicial approach to the interpretive exercise in the kind of cases where there's the nexus between what was then called national security, but was really the security of the apartheid regime on the one hand, and the rule of law. And let me just quickly say that my understanding of the rule of law is that propounded by Tony Matthews in his book, Freedom, State, Security, and the Rule of Law, 1986, in which he said, everybody is subject to the law. All exercises of public power are subject to the law. And that the law means equality before the law and a menu of basic civil political rights, the first generation of rights, not stretching to the second generation of rights. That's what I understand to be the rule of law. But secondly, I want to speculate on the effects of the history of judicial politics. And I think you've got to understand the judiciary as being political because they're involved in the exercise of public power themselves. And that there is something called judicial policy. It's most often not expressed in terms by the Chief Justice or any kind of any other courts or judges, but it is a policy which collectively is understood by the judges as being the overwhelmingly guide to the exercise of their political power. And what my speculating in the last part of what I'm going to say is to talk about the effects of our understanding of the judicial process on the constitutional changes that took place in 1993, 1994. Now, I'm not going to go through all the cases. I've got a list of 1, 2, 3, 4, 5, 6, 7, 8, 9 or 10 of them in any great detail, but I'm only going to deal with the cases which for me show that degree of ambivalence which was present in the South African jurisprudence in the judgments of the courts. And I want to start with a case of R versus Ngwavela. Ngwavela, 1954. Albie would remember that with your middle year at UCT, I think, is the year I was born. Ngwavela's case was the first major challenge to the banning orders that Albie referred to under the Suppression of Communism Act number 44 of 1950. Mr. Ngwavela was a trade unionist and a member of the African National Congress. He was banned from attending any gatherings except for bona fide religious gatherings. And he did not recognize that ban, and he went openly and flouted the banning order. He was arrested and he was convicted. Criminal offense. Thus, a criminal case here, criminal appeal to the Appellate Division in Bloemfontein. And in fact, a case involving Albie's father, Solly Sachs, was used in authority by the Appellate Division in that case. And the Appellate Division held that Ngwavela, that the banning order was invalid because he hadn't had a hearing. The old Latin phrase, audi alteram partem, he hadn't had a hearing before the banning order had been issued against him. And they upheld his appeal. That's at the time of the Harris cases that I'm going to come to again later on. But, well, let me just deal with it now. There was a non-racial franchise, but a qualified franchise in the Cape Province from 1910 to the mid-30s in respect of Black African men, and to the mid-50s in respect of so-called colored men. In 1935, Black African men, 36, were removed to a separate voters' roll. That was challenged by Ndloana unsuccessfully, because the South African Parliament had sat in one chamber and achieved a 2/3 majority, which was the special procedure for doing so. But it didn't create a whole lot of ructions in society. The attempted removal of so-called colored men to a separate voters' roll in the early 1950s really did. It witnessed a process of defense of basic rights by the Appellate Division in Bloemfontein, and I'll come back to that just later on. I must move on. But Ngwavela decision was given in the spirit of Harris 1 and Harris 2, the High Court of Parliament. But what triggered the process of shutting down of any attempt by the courts to rescue basic rights and equality before the law, and to rescue to some extent the limited recognition of the rule of law that had been existing up to now, started in the case of Loza versus the police station commander of Durbanville. The 1964 case went to the Appellate Division. The issue was Elijah Loza was released from 90-day detention under the General Laws Amendment Act of 1963, Section 17. That was the law under which Albie was also detained. And as he walked from the police station, he was rearrested. And his argument was, the law authorizes my detention for 90 days, not a further detention. And the Appellate Division unanimously held that even though the General Laws Amendment Act did not state that it was the police were authorized to redetain somebody for 90 days, nevertheless, there was a reference to on occasion. Those two little words were used in section 17. And in addition, the security police had put in an affidavit to court to say that they'd come into extra information about Mr. Lawser and they wished to continue the interrogation thereafter. The court didn't cross-question that at all, and they said, okay, you can have repeated detention. And we've got an example of that here sitting in this room. And what was at stake there was the presumption of the interpretation of statutes with which the court had used consistently over the years, that where liberty is being deprived by a law, the law must be interpreted restrictively so as minimally to take away such freedom, such liberty. So where the law is silent, you interpret it in favor of individual freedom. As opposed to what happened in Lawser's case, which was the opposite. Let's give an expansive interpretation to the language of the statute, impliedly to authorize a further detention for 90 days. Then we come to Rossouw versus Sachs, and there's an interesting overlap but with the next case that I want to talk about also, which is Schoenbrooker versus Clinton. Albie's dealt with a lot of Sachs versus Rossouw before Van Vincent and Banks J, and it's significant that the two Cape judges, a full bench here in the Cape, found in favor of Albie Sachs. I would like to think that it had something to do with his role as an advocate, his member of the Cape Bar. Who knows? But they recognized in express terms that intellectuals might need, by the very nature of their intellectual qualities, might need for their sort of daily survival sustenance, access to reading and writing materials, and indeed reasonable periods of physical exercise. Again, the presumption in favor of individual freedom was weighed up against the so-called intention of Parliament, which had not been expressed for the denial of reading and writing materials. Again, Albie has mentioned, and it's a favorite point of mine, because again, people seem to think that the bad judges or the horrible judges were only Afrikaner nationalists. Here we have in Ogilvie Thompson, who at that point was yet to become Chief Justice, because he became Chief Justice only in 71. I've often thought that that was partially, or I won't say a reward, but a recognition for the kind of attitude he displayed in this case. And the completely needless reference to champagne and cigars, it sticks. You read that judgment. Why did he have to? So then when you read all these judgments and you read them again and again and again, and you say, why? Why was it necessary to go down the champagne and cigars route, which comes right towards the end of the judgment? He's already justified countless times. He's distinguished the case that Albie was referring to in the early 10s and early 20s, Whittaker and Roos versus Morant and Bateman was the precedent which treated people detained as awaiting trial prisoners. And they said, no, he's not awaiting trial prisoner here. So he doesn't get any of those privileges which attach the status of awaiting trial privileges, awaiting trial prisoners, and so on and so on and so on. So unanimous judgment. Chief Justice Steyn was on the bench. There was an acknowledgement by Ogilvy Thompson that the new regime, Section 17 of the General Laws Amendment Act, was novel and drastic. Nevertheless, and they sided with one of the probably the most infamous decision delivered in the United Kingdom in the English courts during the Second World War, Liversidge versus Anderson, the case in which the detention of people with German origin without trial was tolerated by the House of Lords, and in the face of a very angry dissent by Lord Atkin in that case. And the South African Appellate Division in 1964 knew about all of that, yet they chose to go with the majority of Liversidge and Anderson, and they even acknowledged it there. Sachs's case was heard before Rossouw's case. Oddly enough, judgment was delivered on the same day, March the 24th, 1964. But there was a completely different bench in Rossouw's case, obviously, having been heard on the same, or delivered the same day as there was in Rossouw versus Sachs. Okay. Then I want to move on to what I always think is the third in the trilogy of the cases which really closed the doors. But held a little gap open, nevertheless, because this is for me the wonderful thing about law, and then I'm an unashamed admirer of the rule of law, because for every time the law is used as a sword to take away, nevertheless, there is that aspect of the little blunt edge somewhere which can function as a shield. And the case of Schoenbrooker versus Clint. Clint was the baddie, the security policeman in this case, KLINDT, a 1965 case. Here it was a case that Schoenbrooker was in detention under Section 17. He was allowed a change of clothes, so his dirty laundry would be picked up from the police station by his wife, and she noticed some blood stains on some of his clothes, and he smuggled a little note out to say, I'm being held in solitary and I'm being tortured. She came to court and asked for what is traditionally known as habeas corpus, produce the body, let the person appear. And he said, Rule 9 of the Uniform Rules of Court allows the Supreme Court, the Superior Court, to order the appearance of anybody before them. And she said, and she succeeded initially in the Witwatersrand Local Division of the Supreme Court of South Africa in getting an order to say, where the judge said, let Mr. Schoenbrooker appear before me in open court, so at least I can ask him questions, or this is Schoenbrooker's counsel, and ask him questions about his treatment. That was overruled by a full bench in the Transvaal, Judge Snyman. It came to the Appellate Division, and the majority in the Appellate Division, Botha, Steyn, and Trollip. The jokes about Trollip when he was appointed. Botha, Steyn, and Trollip dismissed the appeal by Mr. Schoenbrooker. But it was a fascinating minority, two minority judgments. One was by the same Justice Rumpf, who decided Rossouw's case about repeated detention without any doubt. For Rumpf, who was utterly unpredictable, John Dugard writes about that to a great degree, Rumpf would have held that the court's power under Rule 9 trumped the Section 17 of the Parliamentary Statute, and the judge should have been able to order Schoenbrooker to appear. And Justice Williamson went further, and the year after Rossouw versus Sachs, he said, with great respect, had I been on the bench in Rossouw versus Sachs, I would have I would now have overruled it, which is a radical thing for an appellate judge to say 1 year or maybe 18 months after precedent has been set. Sternbrooker versus Clinton. Then I want to jump 18 years, to 1986, from 21 years, to Minister of Law and Order versus Hurley. Now we have moved from like ordinary detention without trial, except under the Terrorism Act of 1967, Section 6, the period of detention was no longer limited by days. It could be unlimited, and people were detained for more than a year under the Terrorism Act. Terrorism Act was also retrospective. So anything that qualified as this crazy definition of terrorism under the Terrorism Act, any act committed from October 1962, and which qualified as terrorism could be charged with terrorism. Why? Because they wanted to get the SWAPO defendants, Tuhadeleni, Toyo, and others charged and convicted with terrorism. And in the case of Estate versus Tuhadeleni, they did. But come now to 1986 and come to Minister of Law and Order versus Hurley. And here we're under a state of emergency under the Public Safety Act number 3 of 1953, which gave the Minister of Law and Order, the appellant here, the power to issue regulations. In addition, all the prior security legislation, so-called, had now been replaced by a new Act of Parliament called the Internal Security Act of 1982. And Section 29 of that Act not only gave a pretty wide power of detention to the authorities, but in Section 29(6), there was something called an ouster clause. And an ouster clause, as it was then known, was the authority, or the denial of authority to a court of law to question any action taken in terms of this section 29(1). We've got section, in brackets, we've got section 34 in our constitution, access to courts. That is there because of ouster clauses, I can tell you, because we put it there because of the existence of ouster clauses to take away any possibility of a court interpreting and giving expression to an ouster clause. In Hurley's case, the detainee, Hurley was a Catholic Archbishop of Durban. He was a nominal party here. The detainee was somebody called Paddy Kearney, who was a pacifist, universal pacifist Christian. That means that, as I understand universal pacifism, even if somebody is clapping you, you don't defend yourself, even you don't hit them back, okay? That's how far you take pacifism. Kearney was detained without trial as a violent threat to the law and order of this country. The Durban court, Judge Leon, held that the minister could have, the police officer could have had no reason to believe that Kearney should be detained for that threat to law and order. The Minister of Law and Order appealed to Bloemfontein. Unanimously, the Appellate Division dismissed the appeal. So you've got 1986, you've got the beginnings of the state of emergency, somebody's detained without trial here, and the court unanimously is saying there's an objective element to the belief. It says reason to believe. It's got to be a belief based upon reason. And reason, there are objective standards. And how can you put a universal pacifist in detention as a violent threat to law and order? The most remarkable thing is the judgment was given by Justice Rabi. And Rabi, at that point, the Chief Justice, had chaired the Commission of Inquiry, which had drafted the Internal Security Act of 1982. And later on, he proved to be extremely authoritarian. I can't go on. There are 4 more judgments that I wanted to look at, but I don't have time now. Just to say this, recognizing where I'm speaking. There was a range of cases which involved Abdullah Omar of this university, although a graduate of UCT in the 1950s, but there's the Abdullah Omar Institute here, and he was detained without trial. He was denied access to legal representation in the Cape High Court, but it was a 2-1 split decision. Gerald Friedman, who became judge president later on, would have held for Abdullah Omar. He appeals to the Appellate Division, and it's a 4-1 split. Even in 1987, in that appeal case, Omar Fani and Bill, 1987 is it's known, Hoekster J.A. Dissented and would have held right to legal representation, etc. So all along, there are little sparks of hope, is my argument, in expressing the potential of the law. Okay. Very quickly, what was the pattern of interpretation? Overwhelmingly, up to 1950, and I'm not going to, in my book, Judges at Work, which was based on the Appellate Division's track record from 1910 to 1950, overwhelming executive-mindedness. There's an interesting trend for me. The first Appellate Division was set up in 1910, and the judges on the Appellate Division had all been politicians in one form or another, or deeply connected to political currents in the white English-speaking and Afrikaans-speaking communities of the time. As they retired or reached the end of their time on the court, they were replaced by a more professionalized, if I can call it that, judiciary. Judges who just really been lawyers all their life and not involved in community life. Okay, good. I will finish in 5. My argument is, and I've written something about this, that you can look at the Concord in the same light, and that the Concord was initially staffed by people who had overwhelmingly an intimate political involvement in political struggle. They brought that knowledge and that intuition to their judicial tasks, like the AD did 1910 to about 1920. And then you get people like Chief Justice Stratford, appointed in the 1930s, I think positively the worst Chief Justice we've ever had. I won't get too close to home in referring to Chief Justices post 2005 or so, but there may be some trends there. Okay. I had prepared remarks about why I think there was a shift that took place in judicial interpretation in the late 50s and the early 60s that paved the way for Rossouw versus Sachs and Schönbrooker versus Clint, which are for me the trilogy of cases, closing the door overwhelmingly on interpretation in favor of liberty. There's one aspect which I just have to mention. Most people in the world crave to be liked, okay, and respected by their peers. Judges are no different. And courts in different countries are no different. So because of the colored vote cases, the South African Supreme Court Judiciary, the Appellate Division, got quite a glowing reputation in the rest of the world for holding the line against the apartheid government. Okay, against the apartheid, be careful now because judges are part of government. Holding the line against Parliament and the executive. Okay, the Tuhadaleni case, the first major Terrorism Act trial, broke that bubble in 1967. International Commission of Jurists sent an observer to Pretoria to observe Mr. Justice Ludolf presiding in that trial. He wrote a report, Richard Falk was his name. He wrote a report saying that South Africa has now finally abandoned the rule of law. The Department of Foreign Affairs of South Africa wrote a very angry book. They commissioned a book in response to say how wonderful South Africa was. They're respecting the rule of law. Okay, I'm not going to go through the various studies that have been done of the judiciary, but starting with Albie's book, John Dugard's book, The Work of Matthews and Albino, my own work, Christopher Forsyth and David Eisenhouse are kind of the canon, which set the scene for 1993. And now the last bit, and I'm going to end, and I'll deal with this very briefly. The legislative history, now we're on to part 2, and why do we have section 39(2) in our current constitution, which was section 35 in the interim constitution. The legislative history, the drafting history of the interim constitution, which set the scene for the final constitution, was May to November 1993. In fact, May to August 1993. There were 4 members of the Technical Committee on Fundamental Human Rights. There were a whole lot of submissions from the political parties, none of which effectively dealt with the issue of interpretation of statutes in the way that it is dealt with in the Constitution. The 4 members of the committee were Lawrence du Plessis, myself, Deputy Chief State Law Advisor Gerrit Grovier, and Zach Yacoub, who became a member of the Constitutional Court subsequently. We were all deeply aware of the history of interpretation that I've just sketched and which is exemplified in what Albie told us. And we made 2 proposals early on. Firstly, we proposed for the first time that there should be a constitutional court. It was part of the proposals of some of the political parties there, where we put that on the agenda right up front to emphasize the break with the past, but also because nobody trusted the Appellate Division anymore at that point, because of the history of denial of rights in the Appellate Division from the mid-60s and then strengthened during the latter stages of the state of emergency. There needed to be a fresh start. But the second thing was we put together the interpretation clause, and I just want to read to you one of the reactions. The much respected and frankly principled Chief Justice of the time, Justice Corbett, wrote in response to our proposed interpretation clause that it was inadvisable to lay down rules, any rules for the interpretation in the Bill of Rights. Interpretation is a question of common sense based on judicial experience. Well-known rules for the interpretation of constitutions and bills of rights have been developed worldwide. They've been applied in our courts and by South African judges sitting in other divisions. For example, Lesotho, then Swaziland, and Botswana, and latterly in the Supreme Court of Namibia. We have full confidence in the courts to apply just and equitable rules of interpretation. That was the sort of pushback from the Chief Justice. Nevertheless, the interim constitution went ahead with section 35 and 35(3) in particular, which have now become section 39(2) in the final constitution. And Lawrence du Plessis was the architect of the phrase, which is still in the final constitution: the spirit, purport, and objects of the Bill of Rights must infuse the interpretation of all questions of law. And we always said to Lawrence, what is a purport? But he had some, it sounded like a pulpit, but he had some lovely explanation. Even the politicians, when we had to appear before the negotiating council asked, what is a purport? But it's still there, and they thought to keep it in the final constitution. So whatever, it's about. Thank you very much. That's all I wanted to say. Thank you. 。
Thank you, Hugh. It's an uneven history, it's a complex history, it's a checkered history of sparks of hope, but also a lot of reasons for despair. And I think, I still think it is extraordinary then that in the light of that history, the makers of the Constitution then gives an amazing amount of power to the judiciary, and that is perhaps something that we can further interrogate down the line. But just for a moment, are there any questions right now? Yes, there's a question. There are two questions.
So the thing about the because you mentioned quite a number of things, one of which was the mentioned is African history, So my first question would be, do you think how we remember colonialism and its dispute with the law is intentional, given the fact that we tend to act like colonialism is not legal, or that we have the law. And when we talk about our legal system currently, we have an emphasis on common law. Yet the common law is the same law that we use as Black people. And I would like to say this as not just as an because I'm talking with my privilege when I speak as an officer, to say that when you speak of education, a lot or the vast majority of people in this country do not have access to that. Do you think that is also intentional? By the way, because the Constitution is simply made to serve or at least for the people to have that. Do you also think that fake neutrality, according to me, by the way, is an opinion, that is assumed by the Constitution, as though something did change in 1994 for the vast majority of the country. We only still struggle when we talk about marginalization, when we talk about poverty, it still has a place to stand. There is that fake neutrality, and as Albi said when he said, bogus, full of false promises and pretentiousness, nature of the Constitution is intentional. And yeah, that's just about it. I think I would like to leave it there and also just highlight one last thing. Land ownership pre-1994, over 80% was owned by white people, and that's the other part was owned by Black people. Currently, as we stand, white people own 72% of land, and 28% is amongst Black people. By the way, Black people includes Indians, colors, everybody who would be in the Black region. And the last thing is our over-fixation on our democracy depending on the Constitution. Really, is it really what holds it back? Because if we're really living in a democracy, why can't we have them question those things that governs us?
I saw there was another hand, so perhaps we can take the three questions together. We are running a little bit short of time, so could you please try to keep the questions as short as brief as possible, and then you can take the three questions.
Thank you, Hugh. I'm Emmanuel, and my question, when you were making your presentation, you spoke about judicial policy. Could you elaborate a little bit on that? Then secondly, what is the role, what role does judicial policy still play today in judicial interpretation in South African context?
Thank you very much. Firstly, my question lies very closely with what my sister said over there. Firstly, I would like to even say, as a Black woman from the Black community, in Black families or Black societies, we actually don't report crimes. We don't actually report our sons for rape or anything. This is because we know jail is, when they come back worse. They don't come back better. They are being trained to be criminals. Their sanity is lost in those places. The same jail system that was used back then is the same jail system that we have for our sons right now. So what really changed? Nothing. We still have the same nonsense. We've systemized, or rather there's a systemization of race and discrimination in this country. There's nothing that has changed, and those jails were made for the Black male child who would receive filling up those jails so that it's still the black mage. Then secondly, what we speak about justice, we speak about a constitution that moves about justice. But what is the justice without addressing the issues of race, the issues of discrimination, the issues of land? How do we move forward as legal practitioners? We are here avoiding serious issues. The constitution does not address the land issue. Then we still talk about economic growth, that GNU talks about economic growth or whatsoever. Nothing is really changed. And number three, we speak about the rule of law, which is something that you spoke about so beautifully. As a law student, I've unfortunately been trained to even hate the law even more every day as I continue to study this. What is the rule of law? What is the Bill of Rights? The Bill of Rights is an agreement from the UN. Those are just human rights that were accepted nationally, and we converted all of those things into what we call today the Bill of Rights when you go and study properly into the history. These human rights that were declared and whatever, they do not address our issues. That Bill of Rights does not address our issues. In the rule of law says that you explained it very, very nicely. Everything is subjected to that rule of law. The rule of law, which is against our indigenous customary law. I'm not talking about African customary. Today, the most people in the country, which are the Black people, in which their laws are indigenous customary laws, find themselves being changed to modern African customary law to meet the expectations of what? Of common laws, of white laws. Importantly, more than anything, how can the law that is not of the people rule the people? Those indigenous laws are not, even international law is given greater respect within the Constitution, because there's a clause that states that it should be in line with international law. But unfortunately, when it comes to indigenous customary law, they will always find themselves at the bottom, and they will never find recognition. But instead, in the next 50 years, our children, the Black children, will no longer know who they are. We are being ripped off of our blackness. That is what the Constitution is doing. And it's a beautiful document, but unfortunately, I would like to ask you, is it a great document for the Black people that actually need to be ruled by their indigenous laws? Because when you interpret the law, you interpret it with what? With exactly the Bill of Rights and whatsoever, which is not the law of the people. So how will I trust my child with the court that actually applies only white common laws and not my laws and values that I teach my children in my house?
Okay, I see there's a hand also at the back, but I think in the interests of time management, can we come back to your question a little bit later, please, because we still have to fit in another session. So thank you for the important questions and the very passionate questions. I don't think we can deal with all these questions comprehensively here, but would you like to respond?
Sure. Thank you for those. My remarks, as I was asked to speak, did not encompass the important issues that you've raised. I have absolutely no doubt about the role of law in colonialism. That is why I referred to law being a sword. That if you know the notion of lawfare, it was originally used as a means of describing the role of law to enforce the will of the colonizer on the colonized. My argument is, though, that law can work both ways, and that there's scope within the law to act as a shield as well as a sword. You clearly disagree with the fact that we have a constitutional democracy in the form in which it is here in the Constitution. My response to that would be broadly as follows. These are dumb words on a page in a book, the Constitution. They need human agency to speak. They must speak through Parliament, which are the representatives through a general election process of the people. Parliament must make the laws, and Parliament has made many acts of Parliament to undo some of the damage done under apartheid and colonialism. I'm not suggesting for a moment that the current body of law has succeeded in doing that. But there are many acts of Parliament that have addressed that. The acts of Parliament and the law, the body of law, I do not agree with you that we're dominated by common law. We're dominated by statute law throughout our system. And in fact, an enormous amount of the common law, which still exists mainly in the commercial sphere, has got nothing to do with Roman Dutch law. It's got to do with law which is drawn from a range of modern other legal systems, including those elsewhere on our continent. The judges and the courts have to interpret the language of the law as provided by Parliament. But the critical issue, and where I share as much as I can, and I'm not pretending that I can fully, your anger and your distress, is in the failure, the abject failure by the executive of this country to implement and deliver on the promises, both of the Constitution and the legislation. I would argue there isn't a problem with the Constitution. The problem is with delivering on the promises of the Constitution in so many aspects which it gives, including chapter 12, the chapter on traditional leadership, which reads, the institution, status, and role of traditional leadership according to customary law are recognized subject to the Constitution. One of the aspects of the Constitution is gender equality, equality between sexes. And that is where potentially there may be some tension between customary law and the Constitution. But those are issues which they need to be resolved by the executive, and if there are disputes with them, then they need to be resolved in courts of law. That's my briefest answer to the concerns that you've raised. The Constitution may be amended. We all know that by a 2/3 majority. And so if the aspects of the Constitution, for example, on the land issue, my view is that I would share my view with that of Tembeka Mukaitobi, which you don't need to alter Section 25 in order to have redistribution of land without compensation. It's provided for already in Section 25. Just quickly coming to the second, so I'm trying to deal with both questions here, which covered very much the same area. In terms of judicial policy, what I tried to explain there is that it is something which is not legislated. There's not a document which you can say that's judicial policy. What you do mostly is to look back over a whole body of judgments of courts of law, particularly the apex court, like the Constitutional Court or the Supreme Court of Appeal. And from that, you can discern a pattern of judicial point of view, which then through the doctrine of precedent permeates the other superior court judges. So exactly the same today. I think that if you look at the approach of the Constitutional Court on any number of issues, you can see it's giving leadership, if you like, and that is expressing the collective policy of the judiciary as a branch of government. That's the best way that I can put it. And it affects directly the interpretive exercise. Thank you.
Thank you so much, Stephen. Okay, so I think without further ado, let us then jump right into the third session. Wessel, will you please join us? So I do think there's a temptation today to think of Rousseau versus Sachs as a metaphor, a shorthand for what was wrong with apartheid jurisprudence, and then to tell the story of Rousseau versus Sachs as one of overcoming adversity, both at an individual level and at a collective level. Many of the sentiments that were expressed here today, including the questions, I think, problematize that assumption. And my understanding of Wessel's paper, I'm not sure, perhaps I might be totally wrong, is that he will further problematize that reading of legal history as progressively overcoming the bad interpretive habits of the past. And who knows, perhaps he may even demystify Rousseau versus Sachs's place in the interpretive canon. I'm just speculating. Wessel.
Thank you, thank you, Albie, and thank you for your papers. I'm going to cut my paper as short as possible because I want to leave time at the end for questions and further engagement as we just started. But there's certain key points that I do want to make, so let me share them with you specifically. If you ask a student today, and I'm talking about the period of Rousseau versus Sachs post 1994. So Albie's painted the picture of the case and how he experienced it and what role it played in his life. You followed up from 64 to 94 and the influence of the judgment, and not only Rousseau versus Sachs, but that whole security legislation and interpretation on the transition. I want to focus from 94 to today. And the key point I want to make is that Sachs versus Rousseau doesn't play a big enough role in our understanding of interpretation, and therefore I do not think we've broken fundamentally with the older approach to interpretation. So we need to understand what went wrong with Sachs versus Rousseau and what patterns of that thinking that was present in Sachs versus Rousseau still persist today. So if you ask any student what method of interpretation our courts currently follow, the answer is most likely to say a purposive or a contextual approach to interpretation. If you ask them why that approach is followed or why they say so, they will refer you to certain judgments because the court says so. And the key judgment here would be the Indumeni judgment, and I told Joint Municipal Pension Fund versus Indumeni from the Supreme Court of Appeal, and the Cool Ideas versus Hubbard judgment from the Constitutional Court. Both those cases contain summaries of the interpretive approach, and both say that a contextual or purposive approach should be followed in a certain sense. You could then also ask students, and they would say the Constitution prescribes this contextual or purposive approach. And I think you tried to explain that. The final constitution or the current constitution is unique in the sense that it, unlike the United States Constitution, contains not one but three interpretive clauses to prescribe how statutes enacted under that constitution should be interpreted. There's section 39(2) that says every statute must be interpreted in a way that promotes the spirit, purport, and object of the Bill of Rights. There's section 150 that says if there's a conflict between provincial and national legislation, then an alternative interpretation should be pursued to promote cooperative governance. And there's section 233 that says if there's a clash between the literal or the prima facie interpretation of the statute and an international law obligation, an alternative interpretation needs to be sought in order to promote comity with international law. In other words, there's an obligation in all three of those sections to pursue a specific constitutional value or objective rather than the plain meaning of the statute in a certain sense. The students would say that those provisions also prescribe a contextual approach to interpretation. But if you ask them why those sections do so or why those cases do so, the conversation runs dry in a little bit. Because if we look at those judgments themselves, they don't explain why the contextual approach or the purposive approach should be adopted. Indumeni is a clear example where there's not even a mention of the Constitution in that judgment. Wallace defends a contextual approach on the basis of developments in linguistic theory on the one hand, and developments in contract law in Australia and England on the other hand. And he tries to align our law and the interpretation of contracts with that jurisprudence, and then extends that by implication to statutes and other written text as well. The Cool Ideas judgment is similarly just accepting that these principles of interpretation are now trite and do not need to be reflected on or deeper interrogated. So there's very little understanding of why we adopt and follow a contextual approach to interpretation. And that is my sense that there is not a theoretical or a historical grounding of this method of interpretation that we follow. Sachs versus Rossouw hardly ever comes up, or our experience during apartheid with the interpretation of the security legislation hardly comes up in the discussions post 1994 about statutory interpretation. Maybe you know more, maybe you've read further. I know of only one pertinent debate around Sachs, of Rossouw versus Sachs, and that was a debate that took place in 2011 between Justice Edwin Cameron and Justice John Murphy from the High Court in Victoria at the stage. Edwin Cameron identifies Sachs versus Rossouw as one of the judgments in which the court forsake its own judicial independence. And Justice Murphy responded by saying you shouldn't throw the baby out of the bathwater, trying to defend the purpose of approach to statutory interpretation. So that's one of the very rare, if not the only such engagement around Rossouw versus Sachs. I find that problematic, and I hope that events like this will the importance of historical engagement with the theories of interpretation and the approach to statutory interpretation. So in this paper, sets out that this was not initially the case. At the outset of our transition, there were judges and academics who explicitly referred to the experience of Rossouw versus Sachs and the other security cases in an attempt to open up space for a debate and a discussion around statutory interpretation. I think specifically about Justice Jan Vroneman in those two Port Elizabeth cases, Poliseni and Matisu, in which he cites the critique of the apartheid jurisprudence. He says we should rethink the approach to statutory interpretation for two reasons. We need to rethink the method, but we also need to interrogate the judges. If the judges are now going to exercise more power under a system of judicial review, then they must take seriously the criticism that was leveled against the apartheid judges and come to terms with that. And he cites that specifically in his judgment and says he's trying to rethink what interpretation might mean against this background. That's in the first judgment. He elaborates on that in the Matisu judgment to say, you know, the constitutional system has changed, and that the big criticism of the apartheid judges was that they didn't understand the defects in that constitutional system and didn't make the adjustments in their approach to statutory interpretation. So there is a very specific attempt to enlist the Sachs versus Rossouw string of cases as a counterpoint against which you then reimagine a contemporary approach to statutory interpretation. Those judgments played a key role in one of the early judgments decided by the Constitutional Court, State versus Mshungu. And in that judgment, Justice R.B. Sachs also tried to rethink an approach to not only constitutional interpretation, but statutory interpretation that broke with the tradition. So he tried to reimagine, and he went back to Venter versus Rex, reimagined a certain contextual approach to interpretation, and also warned that our approach to interpretation should not be trapped in the positivism of the past, citing all the literature that you had here in front of us. What worried R.B. Sachs in that judgment was the attempt by both the majority and the minority to take the transitional provision, it was section 241(8), I think, of the Constitution, that said cases that were pending should be continued as if the Constitution had not been enacted. to take the language of that provision as the central reference point and to try and parse and interpret the language of that provision. Both the majority and minority did so. The minority adopted a literal interpretation of that language, and the majority a more expansive, loose interpretation of the language. I think, if I understand correctly, what worried Justice Sachs is this focus on language in isolation as if it stands on its own. That Section 241A should be read next to the Bill of Rights as equal parts of the Constitution, and therefore that the context includes both of that. In other words, you don't enter the context through the language. The letter of that one provision is just one part of the broader context. So that's another attempt where there was a direct reference back to the case law we're speaking about. But that's about it, because in that same judgment, you have Justice Kentridge, an acting justice, who basically rebukes Vroneman for his attack on the judiciary and the referencing to the criticism by the judiciary, and introduced this phrase that what Vroneman is having in mind here, this contextual value-based interpretation, is closer to divination rather than interpretation. And that statement was initially criticized by some academics, but it's now become a leitmotif, a theme that's constantly cited in constitutional court judgments. So the idea that if you open up the context, as Albie Sachs and Vroneman tried to do, you're no longer focusing on the language as such, but you have the bigger contextual scheme in mind that you engage in divination as opposed to interpretation. And as far as I can see it, that's where those early attempts in the sentencing ends. Going back then to Rossouw versus Sachs, in the next part of the paper, then tried to ask what went wrong in Sachs versus Rossouw. And I tried to contrast two approaches to statutory interpretation generally. The one is a linear approach, and the other one is following in the many, what I call an iterative approach. Now, these are terms that aren't usually thrown around when you speak about textualism or literalism. So let me briefly explain best I can in the rush that I'm now in, what I mean by this. It all involves, during the 1960s, a debate about when you consider the presumptions of statutory interpretation. So both Albie and you spoke about this presumption that laws that go against individual freedom should be restrictively interpreted. So statute should be interpreted in favor of individual liberty. That's a presumption. And during apartheid, some scholars said that those presumptions and similar presumptions basically constituted a common law Bill of Rights, which the court should have used when they interpret statutes. That given, the question is not whether you can invoke these presumptions, but at what point in the interpretive process. Remember, during the 60s, parliamentary sovereignty reigned, so the court said that the overriding aim of interpretation is to establish the intention of the legislature. And then there was a hierarchy of aids that you could consider to do so. You had to start with the plain meaning of the language. That's the ordinary meaning rule, or the so-called golden rule of interpretation. If the letter of the law is clear, then you must enforce it unless there's an absurd outcome. If there isn't an absurd outcome, you're bound and stuck to the letter of the law. If the law is vague and ambiguous, you only then can move on to the second level in the hierarchy, in the linear structure, which is the internal and the external aid. Then you can look at headings, and you can look at the preamble or whatever in the statute, and you can also perhaps look at the history behind the statute and so forth. As part of these secondary aids, you would include the purpose and background of the statute, the policy objectives of the government. And only if you've considered those things and you still lack a clear indication as to what the intention was, could you move on as a last stopgap measure to the presumptions of statutory interpretation. Only then could you say, well, we can't figure out what the intention was, so we're going to presume it was, and then you invoke the common law presumptions. This understanding, this linear approach to statutory interpretation was formalized in the early 60s by a guy at UNISA called A.C. Sylvia. And it was adopted by Halem and Khan in their textbook, Introduction to South African Law, where they set out the rules of statutory interpretation. Just after Rossouw versus Sachs, a colleague of Sylvia at UNISA called Marinus Wiegers took offense to this hierarchical and linear approach to statutory interpretation as to when you can consult the presumptions. Remember, right at the end. He said you start with the presumptions. The presumptions are there. It's a co-equal part of the context, and therefore it's not something that comes right at the end. It is basically the reference point, the starting point. You try to uphold the presumptions unless there's a clear indication to the contrary. So you begin with the presumptions and then move forward. Lourdes de Plessis adopted that line of thinking in his 1986 textbook. But when it came to the discussions that you and Lourdes had, he had changed his mind already. He was moving away from this linear approach to statutory interpretation to adopt an iterative approach, or what he calls a holistic approach, where the various aspects of the context are co-equal elements to be considered together as one unitary holistic exercise from the start. So the point I'm trying to make is that Lourdes then started writing out this new approach to statutory interpretation in his 2002 book, where he recategorized the canons of interpretation, not as first order canons, the second ones, and then the third ones in terms of hierarchy, but in terms of canons of teleological interpretation, historical interpretation, comparative interpretation, schematic interpretation, and grammatical interpretation, and regarded all those modes of interpretation as co-equal and something that must be engaged in at all times. Now, I think, and I would want to suggest that what was wrong with Rossouw versus Sachs is this linear approach to statutory interpretation. In the sense that you start with the language, then you move on. They came to the purpose and they settled the question on the basis of the purpose, and therefore there was no need to move on to the presumptions at the end. That linear structure remains in place. If the language of the law is clear, then you start with it. So a lot of the criticism of Rossouw versus Sachs said that the freedom the court has to get to the presumptions only applies if the language of the law is not clear. If the legislature enacts clearly and else something, then you start with the language of the law. That is problematic from an iterative perspective, because the iterative perspective does not enter the contextual scene through language necessarily. You enter it at any point through the values primarily as the starting point. I hope I'm stating my idea clearly enough. So what the point then is, you can replace parliamentary sovereignty and the search for the intention of the legislature. You can scrap that as a constitutional thing, as we did with our constitution, but unfortunately retain this linear line of thinking. So you take the language still as the screen or the bracket that precludes you and prevents you from getting to the value questions involved. Now you would say that goes against the interpretive provisions, but that, my fear, is exactly what our courts have done. And it starts with Kentridge in State versus Mshlungu that said, if you don't work through the language, you're busy with defamation. And so in the last part of my paper, I tried to explain and give you a number of examples where this focus on the language is remaining suffocating and preventing us to rethink our approach to statutory interpretation that fully adopts a contextual iterative approach. There's still, even on the part of the Constitutional Court, a reluctance to get to the constitutional values as a result of the limits imposed by the language. So I'm just going to run through these quickly. If I had more time, I would have explained. Let's take the story up with Fruneman and Sachs's early judgment and attempt to rethink the place of values in our approach to statutory interpretation. Fruneman was rebuked by Kentridge in that early judgment on Mshlungu. He was rebuked in one of the last judgments that he wrote again in the New Nation Movement judgment. In the New Nation Movement judgment, the court said that independent candidates have the right to stand for office because Section 93 says every adult citizen has a right to stand for public office. And Ron Furman wrote a minority judgment in that case to say you have to understand Section 19.3 against the background of the values in the ethos and the conception of democracy that underlies the whole Constitution. And you can't take the language out of context and look at it on its own. That is exactly what Sachs worried about, that the majority and minority were doing in the Mhlungu judgment. This is exactly what the majority does in the New Nation Movement case. Yafta says what Furman is trying to do is a form of divination. All he is interested in is the language of Section 93 and in a literal way interpret it. Then he's looking for other provisions in the Constitution of equal force that can be treated as an exception to Section 93. He doesn't find any and he concludes that there's a right for adult citizens to stand for public office. So Furman's attempt to rethink a value-based approach is framed from the beginning to the end, from 1995 to 2020 when this judgment was decided, by this reluctant to embrace that. Other examples, and I'm going to stop now. Daniels versus Campbell, the attempt to prefer direct invalidation of statutes over the reinterpretation of statutes. In that case, R.V. Sachs tried to say the term spouse should be reinterpreted from apartheid era legislation using Section 1939(2). Moseneke for the majority said, no, we don't tinker with the meaning here, just invalidate the thing, we have the power, and then we can redraft the legislation. There's a tendency to prefer this invalidation over interpretation because you don't want to tinker with the clear and ordinary meaning of statutes. It's best to make use of reading in rather than reading down for the sake of clarity of interpretation. A clear example, Justice Cameron and Fourie, and I'm talking about the Supreme Court of Appeal judgment, where maybe I should just say there's the cases where you see the traditional hold that the Rossouw versus Sachs linear thinking still have over our imagination. You see in cases where lawyers for some reason fail to challenge the constitutionality of a statutory provision. And so therefore the courts are limited in what they can do to the methods of statutory interpretation. That happened in the Fourie case in the lower courts initially, because the lawyers didn't challenge the marriage formula in the Marriage Act, and whatever you then develop around the common law, you stuck with that marriage formula. In the Supreme Court of Appeal, Farnham says that we just adopt a value-based interpretation, a purpose of interpretation, then we can upgrade or update the marriage formula and replace lawfully whether husband and wife with the term spouse, because that's what justice requires. Cameron said, and I quote him if I can, he knocked this down and he said, no, you don't have the power to do this because you're tinkering with the language. And this is his words. He says, radically innovative statutory interpretations of this kind were devised, as the authority Farnham quotes shows, for jurisdictions which do not or at the time did not have the ample remedies of constitutionalism. Under our constitution, the proper interpretive approach is plain. If the wording cannot bear the meaning, then you have to declare it valid and read in. To say that the strategic, radically innovative statutory interpretation are no longer needed in South Africa because we've got the power of invalidation, we don't have to worry with interpretation, to me is a sign of this old head. More particularly, the Cool Ideas case that I started off with, the quote says, and it starts off, the summary of the current interpretation. Listen to this. It says, Majid is talking, he says, a fundamental tenet of statutory interpretation is that the words in a statute must be given its ordinary grammatical meaning, unless to do so would result in absurdity. That is the classic golden rule from 150 years ago. The language must be adhered to unless you can prove an absurdity. And then lastly, perhaps, Justice Turon in the Van Zyl judgment, the 2021 judgment, a very interesting one where prescription was involved under the Road Traffic Act. Person wasn't under curatorship, but was mentally defective and therefore didn't know that he could institute this claim. He was also not held in a mental hospital, and those are the only categories allowed for under the Road Traffic Act. So it's fundamentally unfair that this person, simply because no curator was appointed, which could have been appointed, that prescription would run against this person, whereas if a curator had been appointed, prescription would not run. And the majority finds, with reference to natural law, that the common law principle that nobody can be expected to do the impossible still applies and overrides the statutory exclusions, and therefore that prescription did not run against the person. A second judgment, concurring majority, held that the normal interpretation actually applied and not the road accident fund. But to Ron and her minority judgment basically says the following: she rejects all of this because she says this value-based, this constitutional teleological interpretation is not open under the law, and she relegates the role of the Constitution to the last level again. Remember what I said in the hierarchical approach. She says the section 39(2) inquiry therefore presupposes that before this section can be invoked, the court is able to identify interpretations that fit the language and the purpose. This means of necessity that the section 92 injunction can only be applied after reasonable interpretations have been put on the table. To hold that section 39(2) itself informs the context is to put the cart before the horse. This is in so many words to say 39(2), the value, spirit, object, and purport is not part of the context of statutory interpretation. The context is the language, the purpose, the structure, and you have to justify your interpretation as reasonable on that basis. And if you can't do so, then you can't rely on 39(2) to do so. Let me stop there. The point I'm trying to make is that the problem that was encountered in Rossouw versus Sachs, the fact that the presumptions or the values wasn't invoked by the courts, was relegated to the last in a hierarchy, in a certain sense persists in these cases that I've showed you now. I think it could have been different perhaps if the courts here do not just cut and paste each other's summaries of statutory interpretation, but it engages more deeply with the historical reality from which we come and why it is that 39(2) was adopted, why it is that you don't want that linear approach. You should adopt a more open-ended contextual or iterative approach to interpretation. I'm sorry I took up your time. I carried on longer than I thought, but that's me for now. Thank you.
Thank you, Wessel. So I think we are at a somewhat inconclusive note. The courts have not fully left behind the Rossouw versus Sachs. They have not fully left behind the old interpretive approaches and canons and habits and all of that. But I don't think we are at a hopeless point because what you suggest is clearly an alternative approach. Okay, but let me shut up. Questions, please. So questions for Wessel, but then I think, yes, certainly the other panelists should also join us. So questions for any of the panelists. Okay, so I'm going to begin with you right there at the back.
Someone switch me on.
You want to respond to this early question?
I'd love to respond to the very passionate, deeply felt commentaries made by our colleague at the back and the colleague to say there's an elephant in the room that's not enough. There's an elephant in the room, and there's a lion in the room, and there's a springbok in the room, and the beautiful birds in the room. And it's wonderful that you're posing the questions. It's wonderful you feel you're in a safe space, you can raise it. There's not going to be any repercussions. The case of Elijah Rossouw was mentioned. He was my friend, he was my comrade, we were underground together. He died, he was killed, he was tortured to death. The case of Govela, he was my comrade. He was the office manager for Sam Khan, the attorneys. He came, he lived in Langa. And generations of Ngovelas joined him Mkontowisis, where some died. His granddaughter became the consul general in New York. These were African people. They were fighting for rights. They used the language of rights. It was the whites who were saying black people don't want rights. Don't know about democracy. The black people want to live under their tribal leaders and have enough food to eat and a roof over their heads. And Elijah and Wabela Johnson believed in rights. And the ANC had a Bill of Rights in 1923. ANC came together to get beyond the tribal divisions, which the whites were using to divide everybody. In 1944, at the time of World War II, when Churchill and Roosevelt got together for post-war, post-Hitler world, the leadership in South Africa was saying, what's going to happen to us African people, black people? And it came up with African claims that included a Bill of Rights. The Freedom Charter was adopted at Kliptown in 1955. I was there. There were maybe 10 white people there, maybe 20, 30 colored people, maybe 40, 50 Indian people, 2,000 black people demanding their rights. We want rights. We want the vote. We want power for the people. And we refused to accept Bantustans and being divided up under different tribal leaderships. So that's the paradox. The whites were saying black people are not interested in rights. And the black people were saying we want rights for everybody in our country, even generously including the whites as well. The Constitution was drafted in Parliament, 490 people. Of the 490 people, more than 400 were black. And they weren't black stooges. They weren't blacks trying to be like the whites. They were blacks who'd been on Robben Island, they'd been in prison, they'd been in exile, in the resistance. They were thinkers, clever, smart thinkers, thoughtful people. And they drafted that Constitution. And the objective of the Constitution was, number one, to completely destroy that whole system of apartheid, of people's rights and dignity depending on their skin color, the language they spoke, their beliefs and so on. Destroy that completely, but it was more than that. It is to affirm the human dignity of everybody, that everybody counts, everybody matters. And it included the women's movement, played such a big role, African feminists, with people like Baleka Mbeki and Mavivi and others. And they were saying, we don't want power to go from one gang of men to another gang of men. We African women, and they spoke as African feminists, those were the ones who insisted customary law is okay, but the way it's been applied is completely patriarchal, and we don't want to be subordinated and dominated by our fathers and our brothers and our sons. We want to have full dignity in the New South Africa. And they were the ones who insisted that the equality principles be applied to customary law. And interestingly, it was the white judges in the courts who insisted on keeping patriarchy as part of African culture. and it was Yvonne Mahoro. Yvonne Mahoro, my dear sister Yvonne Mahoro, she was the one speaking about the importance of overcoming patriarchy. It was Pius Lange who wrote the judgment in the Bear case. Pius didn't want to please anybody except the people, except the ideals for which he'd struggled all his life, in the form of rights. So it's great that you've raised these issues, but I think you'll find and you'll discover wonderful Black people, deep thinkers, passionate believers, people who had a rich vision of the world, completely independent inside themselves. They were at the forefront of the whole constitutional project. And that even has a bearing on the very refined legal discussion that you introduced. So it was like 197 kilometers per hour. You know, you see in Wimbledon, not easy to keep up with the speed, and made worse because you knew you were short of time, so you spoke even faster. But what we found sitting as judges on the bench, it was a change. I don't call it simply of policy. It was a change of legal culture. And legal culture was not only in terms of legal thinking, but even style, collegiality, working together, workshopping, refusing to be called my lord and my lady. It's strange in South Africa. The top court, we just justice. You go down to SCA and down to the High Court, it's my lord, my lady. We didn't like that stuff. We didn't want that stuff. We wanted the real sense of equality. You're not begging when you come to court, begging for a claim. You're coming to affirm and assert your rights. And we grew up with dictionaries. That was the most extreme example of literal interpretation. And you'd have the Oxford English Dictionary, and you'd have Chambers Dictionary, and you look for the dictionary words that supported your interpretation of the words. We don't do that anymore. The Constitution is very clear. You interpret common law, customary law, statute in keeping with the values of the Constitution. It's a whole different approach. And we've actually said, even if it goes against the meaning of the words, we've said that. I wrote it. Against the meaning of the words, provided it's not so against the meaning of the words that of the Constitution, the words that it's breaking, it's too much, then you have to strike down. So it's given enormous latitude to the judges, moving away from presumptions. We would have pockets of presumptions. The prosecution had theirs, the defense had their presumptions. Basically, the judges were left in the old days to choose between the prosecution presumptions and the defense in criminal matters. So I'm very delighted that the approach I adopted in Mhlungu is the one that you like. That makes two of us. The statement by Sidney Kentridge, who is great lawyer. He's still alive. He lives on forever. He's 104 now. And he carried on practicing into his 90s. He was a literalist. And in that case, the Mhlungu case, the provision at the back end of the Constitution said judges sitting in the courts don't have to be sworn in again. They carry on to have continuity. And it said cases that started before the Constitution came into effect have to be dealt with as though the Constitution hadn't been enacted. And we were sitting around the table. Now I'm giving away secrets. You're not supposed to discuss what happens around the table, but you'll see why I feel I can do it. Sidney Kentridge, the words are very clear. And if the unfortunate results, you have to deal with them in one way and another. But it's very important that the Constitutional Court follows the language. It meant if there's a racist statute that's still there, unless the statute's been struck down, you can't apply the Bill of Rights. It meant capital punishment, which we're still discussing, continues, and then you have to get executive clemency. Laurie Ackerman, I agree. Arthur Truskelson, I agree. Somebody else, I agree. LB Sachs, I disagree. I couldn't say why. I just felt this is a new dawn. The idea that from the day the Constitution's enforced, we can still have capital punishment, we could still have group areas, we could still have racist things. It's absolutely intolerable. It's intolerable. And that provision was put in the Constitution purely for practical purposes, that you don't have to start the case all over again and waste time. It wasn't put in to allow these horrible things to continue into the future. But I couldn't explain it then. And then Yvonne said she wants more time. Kate wanted more time. Pius wanted more time. Interesting now, the non-former judges who were supposed to be the weaker people on the court didn't like this idea that there could be a permeability into the after the day one. And then Islam Muhammad's listening, and he became the leader of if you like, of the ones who had to find another way. And he put everything on the word dealt with. He says the word dealt means procedural. And I wasn't happy with that. Dealt with, yeah, that's what that provision is saying. But the Bill of Rights is saying something else. And what happens when you get a clash between a puny division that's transitional on the one hand and a powerful fundamental rights? You try and reconcile them as best we can. Indian Mhlungu at least put in the purpose of approach. And the purpose of approach, I don't want to please the West. In my lifetime, the West had concentration camps and bombing and genocide. The West had colonialism and domination. The West brought gallows and hanging to South Africa. The West brought racism to Africa and South Africa. I don't want to please the West, but I feel I was part of that liberation struggle of people fighting for their rights, and we got it in the Constitution. And having the Constitution gives us the weapons, the armory to deal with all the injustices that continue to deal. It's there. And we got the Constitution through mobilization, through demonstration, even at one stage through armed struggle. And the issue then is not to do without the Constitution. The last point to make is a very important part of my life, two important parts. One in Mozambique and the other in Kenya. We had people's power in Mozambique. It seemed fantastic. The masses in cities and the rural areas coming together with progressive intellectuals to transform the country. But we found without opposition, opposition doesn't go away. It goes underground, it fights back. And that country was torn to bits. I lost an arm. And so many Mozambicans lost their legs to landmines. They had child soldiers. They had millions of refugees. The economy was destroyed. So pluralism, contestation, elections, they're not Western things. I think people throughout the world have fought for. And they came to Mozambique at a terrible cost. I was in Kenya, and that whole generation, do you know Ngugi wa Thiong'o? You don't, it's the older generation know Ngugi, the great Kenyan. He was imprisoned by, at the time of Moi and Kenyatta, and they used what they called African tradition to support a one-party state. You don't have controversy. You don't need trade unions. You don't need opposition parties. And they threw the patriots into jail, and it was African patriots fought for multi-party democracy, for rights. So for me, I'm speaking with a degree of emotion here. These were our lives, and I was in a movement, a Black movement, African movement. They accepted me. It's a wonderful thing for me and generous thing for me. Don't wipe out their achievements. Don't hype out their values. Don't hype out their idealism. Be as insistent as you've been, as critical as you've been, but also study the Constitution. Look at Section 25. It deals with the land. It gives people rights to land. Section 25. Have you read it? Yeah. It says it places duties on the state to make land accessible. In which one can get into all the details. Tembeka has studied the negotiations, and he said the ANC had 3 positions, they won all those positions. The problem, according to Tembeka, is the victories that were won in negotiations haven't been built upon and haven't been developed. And you are the generation that I believe ought to do that. So it's Law's pretensions that the Constitution solves everything. It doesn't solve anything by itself. Law's possibilities is that everything that was invested into that struggle to get those freedoms, and I think particularly of the African feminists fighting so hard to ensure that patriarchy was not going to be consolidated in the new South Africa. All of that is something worth retaining and building upon and learning from, and maybe meeting some of the people of that generation and discussing how they, as Black women, saw these particular issues. So fight on, but also use your brain, your intelligence, your sharpness, speak to others, keep the controversy going.
Okay, I suppose very happy for that only, but I suppose starting up with your permission, can I ask that we just give the other 2 speakers to say the final word, and perhaps yes, I feel that we owe you that one question. So is that okay? If we keep it brief, just one question, and then a final word from you. Yes. Is that microphone not working? Is it that?
Yeah, I can just figure out it's okay. My name is Lucario, and it's an interesting conversation that's going on here today, and I just would like to juxtapose the conversation and the experiences against the most contemporary issues that we have faced, in particular in relation to the right not to be detained without fair cause and without proper trial. With that, I'd like to put it to you, former Justice, that in most recent history, we have the former President Jacob Zuma, who was sentenced to 15 months in prison, and it was done so by the apex court in our country. And with that being said, we understand that there is no appeal for such judgments made in the Supreme Court. So, having fought for freedom and the right to out and the right not to be detained without just cause, and the sentence of Jacob Zuma coming from a civil matter, and it being the first of its nature, and considering that you can't appeal it, what is your take on that? Do you perhaps think that the court achieved its purpose? Because in whatever the court does, it must look out for achieving its main purpose, which was to bring Mr. Zuma to account in court. And him being sentenced to 15 months doesn't necessarily achieve that. And then also being done without the trial, and you have been detained for certain period of time and detained without trial. What is your take on it? Do you perhaps think that another approach could have been taken, and the Section 12 rights of Mr. Zuma, Section 35 rights could have been interpreted in such a way that he is not unjustly detained as some of the time, so even 2 justices did not the judgment. Perhaps if you being still on the bench,
Yes. Okay, and I'm not going to go there. Jacob Zuma was my chief representative in Maputo. I worked very closely with him, and he was a good leader then. And every December 16th, we would go to the cemetery and we'd clean the graves of our comrades who died there and were buried there. And we'd look at the space around, wonder if we would be next. So I have nothing against him. But the issue was dealt with very, very fully, not in 1, in 2 judgments by the Constitutional Court. The majority disagreed with your position. Study the majority and the minority positions, and you can decide which one is more persuasive. But the detention without trial, it wasn't that clause that was, in particular, that was invoked there. It was the idea of the contempt committed in the way that it was, and the majority felt that the law, the Constitution was completely complied with.
Thank you. Can I perhaps just ask a placeholder question, just for you to close, and then you can also confirm those words if you thank you. So this quest for an iterative approach, is it a lost cause? Is it a Sisyphean task in view of the clearly legalistic nature and the preference of our legal culture, and I think also even our legal education for certainty, clarity, clear rules which can be followed in a linear way? Or do you feel that this is an approach which should be inculcated in legal decision makers, and that could truly be transformative?
Yes, I do think it's an approach of a lot of potential. It's an approach that is democratically needed in the sense that it is the best way of holding judicial power accountable. It forces judges to put everything on the table and to make an open value judgment. So the iterative approach is basically asking judges to consider the context in all its facets, seeking to promote the law or turn the law into the best law it could possibly be. That means the law must be as clear and certain as possible, internally consistent as possible, as efficient and rational as possible, and as socially just as possible. And that comes down to what is generally regarded as the textual context, the sentence context, the grammatical context, the textual context, the policy context, and the constitutional context. All of those things, in terms of the iterative approach, are recognized as co-equal aspects of the context. So when you interpret a rule, you're trying to maximize those constitutional values of certainty, consistency, efficiency, and social justice. It's not always possible to do so. And then the difficult judgment call comes in. Do you compromise clarity for the sake of social justice? You compromise social justice for the sake of clarity, and so forth. Efficiency, and what Rossouw and Sachs did wrong is to compromise the social justice aspect, the freedom of the individual for the sake of the efficiency of that law. So you're correct to say they should have considered the purpose behind the rule and the aim of the detention regime, but should not have allowed that to trump the other values that were at stake in that case. So the value judgment they made was incorrect. You try to eliminate that value judgment through the linear approach, because saying the language is clear, then there's nothing else to do, you just apply it. If the language is not clear, you look at the next level, and so you try and eliminate the difficulty of choice, and therefore the need to take responsibility to justify those decisions. So if we can break through that and see the value judgments that are at stake, because sometimes, say in a criminal matter, it's more important, or it's, let's say, in a criminal matter, you can think that legality is more important than perhaps social justice, whereas in other areas of law, social security or socioeconomic transformative matters, the social justice aspect is far more important than the clarity aspect. And so those kinds of value judgment will depend on context. So which of the contextual factors should dominate is also a contextual question. It's all context. And once we embrace that, we will have better justification of power. And that comes back maybe my response to the student's question. I see law and the Constitution, statute law, as a means to enable you to call power to account, to enable court to review decisions taken by other people in power. And You do so through checking the rationality or the reasonableness or whatever through the interpretation. It's all about accountability, justifying the power that the state wields. And so this iterative approach provides a much better justification for any judgment and therefore exercise of state power than the old iterative approach. Thank you.
Thank you. Thank you for a thoughtful and a lively and a wonderful session. And please look out for follow-up RULCI debates on interpretive and other issues. Thank you so much.
And you, Bev, who arrived here, Bev Miller, behind there. He doesn't know where her car is because she had to park somewhere else. I wonder if you could, if Vessel could help her find her car. I've got to run. I've got another engagement now. We run a bit over. So I will, I'll maybe ask Bev.
Thanks so much.
Okay. Yes. Thank you. Okay, Alvin. Yeah. Thank you, Vessel.